The name is T. Lex. Get it, Lex? Oh, gosh.
I get it.
Norm!
That's just paper.
It's paper or plastic, yeah. I'm walking inside of a beach ball. Getting started in a few minutes, folks. Crap. Anybody got the time?
Well, actually, 9 o'clock straight up.
All right, let's get started. Sorry? Yeah, so that you can see the screens a little bit better. Make it dark like it was. Did it hurt anybody? I'm just making sure. All right, let's get started. Hey, everybody. My name is T. Lex. Nobody gets that joke? Damn. Welcome to the 28th annual CALIcon. Woo! It's really hard as a dinosaur to hit a mouse button. We are so happy to be here at American University, Washington College of Law. And I wanted to introduce Camille Nelson, Dean Nelson. Even though in my time I was the apex predator, we all know that in law schools, deans are the apex predators. So come on up, Camille, and join us.
Good morning, everyone. John is making me very nervous. As a tort professor, not even the sort of whole thoracic element.
Yeah, the crazy factor. Yeah.
That's the, don't fall off of that.
Well, good morning, everyone. I am thrilled to see so many of you here on this bright and early morning. Thank you for the introduction, John. I extend my gratitude to all of you and your colleagues at CALI for your more than 3 decades of contributions to the legal educational world and professional development through innovation and technology. And it is my distinct pleasure on behalf of American University, Washington College of Law, to inaugurate and welcome you today. I want to say particular welcome to all the faculty members, to all the law school administrators, law librarians, students, alumni, IT professionals, especially those of you who have traveled from far and wide to be here for this event. I hope you will enjoy your time at our lovely Tenley campus and do explore. We're very proud of this 8.5-acre facility. As you know, we are in the midst of a technological renaissance. I've described it elsewhere as a revolution in real time. As we celebrate, as John said, the 28th year of this conference, it's really hard to believe just how technology has changed over our lifetimes. I often say to my kids, and this really dates me, but you know, When I was growing up, we didn't have a microwave for a while. When we got a VCR, it was like a huge deal. We'd go to the store and peruse the shelves, right? The internet, all these things, and they sort of like, yeah, Mom, like basically you're a dinosaur, right? But when you think about all of these things, as I joke around, and I say to my husband when he's traveling, Alexa is my best friend when you're not here. She keeps me company. Things that have morphed so quickly in our lifetimes. We don't have to look back very far to see a tremendous evolution. And I really do think this conference provides an opportunity for us all to think about how technology will change in the next 3 decades. We know it is a non-stop process. It was in 1982 when Time magazine named the computer its, and I find this really interesting, Man of the Year, right? After IBM introduced its first PC. And in 1983, many of you will remember the brick was introduced, the Motorola Dyna TAC. I had one of those mounted car phones. I was very proud in my Buick Skylark to have a mounted brick in the car. And today, when we think about our family members and youth and our children as they grow up, they're growing up in a radically different world. Just 2 anecdotal, tidbits that I seize upon, because it really does indicate where we're going and what does this mean especially for those of you who are legal educators. Years ago, when I used to teach at SLU and I was at WashU, we went and we rented a cabin in Missouri, in the country. It was like a YMCA lodge. Trout Lodge, I think it was called. And the lodges said they had phones, and the phones were rotary phones. And we have 3 teenagers now, but then they were like, 6, 8, and 10. And I remember them looking at this and going, what is this? And it seems so ridiculous. But they literally were looking at this beige phone with the dial system, and they really didn't know what it was. Now, I'm sure they could figure it out, but they thought it was comical in a way, especially how slow it was. When I taught in Boston, there is a wonderful YouTube clip of, I believe, a young girl who is 3 or 4, and she has a magazine, and she's sitting on a deck, and she's going like this with it, trying to spread it like the iPad, and she's trying to figure out, and we just go flip, flip, right? But there's just a way in which you look around and you'll see very young children manipulating technology in quite impressive ways, and they're growing up with that. So if you fast forward a few decades when she's here, what are her expectations? And I think we need to be thinking about things like that as we approach the future. So this digital generation is coming of age and entering into the workforce, our educational communities, and we really need to think about their expectations. And I think while technology, as we hear, has always been at the forefront of the human experience, the practice of law and legal education now really do face an unprecedented sense of challenges, but I also think there are tremendous opportunities if we engage with them as such, as we try to keep pace, but also to be ahead of what's next. And I don't purport to know what's next, but I think if we engage creatively, especially with the youth, they have a good sense of what is coming. And they're on the vanguard in so many respects. So I think this is a really interesting epoch, as it were, as we think about how we leverage technology and other innovations. And I will say this, I was born in Kingston, Jamaica, and as a person who is greatly concerned with disparities, I think that for many of us, we recognize the luxury and the luxuriousness of technology and expectations of technology. I went back to my office to make sure I had my iPhone, right? Like I needed it in the 10 minutes I'd be here, right? But we're just so accustomed to it. But for many of our millions of people who live in this country, financial impediments and resourcing issues really prohibit and are barriers to effectively engaging in technological, digital educational platforms and in other innovative opportunities. So I encourage us to think about what that means as we think about access to what technology might do to elevate and to uplift across jurisdictions, across this country, and across the world. So as you participate in your informative sessions, in your presentations and workshops, I really encourage us to think about how we as legal educators in particular, and as people who care deeply about the power of technology in this hyper-innovative era, make sure it is equitably available. And with that, I really do want to thank you all for being here. I hope you enjoy your time. We are here to be at your service. I think I'm going to get eaten if I don't step off, but my warmest welcome to you. Enjoy. Take care. Thanks, John.
Thanks, Dean. So in case you didn't notice, I'm a dinosaur. And in case you didn't notice, I like to dress up in goofy costumes for this conference, but it's never without a purpose. I hope you realize I'm a walking metaphor here, right? It was many years ago that I first heard, actually it was Peter Martin say something like, change or die. I heard Ron Stout say it many times. Both Peter and Ron were past presidents of the Cali Board of Directors. And it was only later I found out that it was Bob Baring. So, you know, so the news comes from these three old dinosaurs that we need to evolve, or we're going to be replaced by the mammals, right? I like to believe that Cali is sort of like the Bell Labs or the DARPA or the Skunk Works for legal education. Maybe not so well funded. But you know, we've been writing Cali lessons, I swear to God, since 1978. You know, we've been doing ebooks since 1992, if you remember Folio Views. We were doing podcasts. I mailed out over 100 of these MP3 recorders to faculty to encourage them to do podcasts back in 2005 and 2006. Been working on access to justice issues for over a decade. And of course, this conference got started way back in 1991 by Tom Bruce and I. At the first one at an old crappy building that Chicago Kent was moving out the next year. That was our impetus at the point. Was we knew we were going to move into a new building, so let's have a conference in the old building, kind of a compare and contrast thing. And ever since then, we've been walking around the country, going to people who have brand new law school buildings, such as this magnificent facility, kind of forcing you to take a busman's holiday. If you don't know what that means, look it up. You know, to come and visit, and because also the building of a new building is an opportunity for law schools to inject a lot of technology, or at least to think about a lot of technology issues. So here we are. So we've transformed, rebooted, unbound ourselves, driven innovation, you know, for 28 years. To end up where we are now. The theme is engaging law students with tech, which is almost like the theme of all time, right? It's literally, it's so simple. It's not very clever, you know. So I had to be clever with the costume, I guess. But it fits our mission perfectly, right? Our mission is to be an explorer and a researcher and a developer and a distributor and a publisher of things that involve technology and overlap with legal education and access to justice. So I have a whole bunch of people to thank, but I like to thank fast. I especially want to thank American University for inviting us, and I especially want to thank Billy Joe Kaufman for being the only person who's ever hosted two conferences at two different law schools. Thank you, Billy Joe. Whoopsie daisy, see, hitting them too fast. Back. Of course, we have a bunch of sponsors, and we love to engage our sponsors. We invite them to the sessions. We don't want them to just sit at their tables. We want you to go visit them. We're happy to have C Webinar, ExamSoft, Xtegrity, Exam4 here, and of course the Free Law Consortium. Probably, did I pronounce that right, Tim? Just free. All right, good enough with free. iLaw, which is a Barbary company, wonderful. LexisNexis, good to see them. And the National Society for Legal Technology. Thomson Reuters, always wonderful to have them. Wordrake, Fastcase, and PowerNotes. and Carolina Academic Press, thanks for coming, Charter Course, and the architects of this building, Smith Group. So there's all of them on one screen. Thank you, folks. Thank you, thank you, thank you. Can't thank you enough. Now, there's more to that. There's a way to engage with those folks. You all have a piece of paper, or you were given a piece of paper. It's for the raffle. And the point is, you're supposed to visit these vendors, and they give you a sticker, and you have to visit, I think it's 8 of them. And we're going to have a raffle at the end of events tomorrow. So it's not a raffle where you get weird, where you get normal stuff. It's weird stuff. So we've got a couple of Echoes. We got some Bluetooth hats. We've got a working model of the DeLorean. Yes, it's small. It's not a real DeLorean. A couple of drones. This is the coolest thing. We got a waffle iron that makes Death Stars that we're raffling off. We got Mjolnir, Thor's hammer, but it's a toolbox. We're going to be raffling off 3 of those. Imagine walking into a faculty's office with that and putting it down. We've got an endoscope, which you, I'm not going to go with that joke. We've got some fish slippers, I swear to God, and a notebook that you can write in and then put it in the microwave and all the things disappear, so perfect for, Washington. And also some of those little stick-ons that basically put a little slider over your camera so Facebook can't watch you while you're doing your homework. So, visit the vendors, get the stickers, put it into the raffle box that's at the registration table, and that will be wonderful. Of course, have to thank my staff. I got the best staff in the world. They're a great bunch. And we have a lot of fun doing this, and I especially want to point out Elmer Masters and Scott Lee, who carry the brunt of the effort for this. Is Scott in the room? Is Elmer in the room? I want to embarrass them. No, they know to leave when I'm doing this. Thanks, guys. I also want to thank, and I always forget to do this, I want to thank my board of directors. They're a bunch of volunteers. They put effort and time into Cali. This is the executive committee. Jennifer Martin is the president. Chris Niedringhaus is the vice president. Sally Weiss is the treasurer. And of course, the secretary is a man, so it's Scott Burnham. Don't forget, the Wi-Fi here is at our AU guest by RCN. There's no password or login. The always up-to-date schedule is at CALIcon18.sched.com. The one that's on here, we did our best, and then we made mistakes, and then we put stickers on it. We hope it's accurate, but rely on the Sched schedule more than anything else. If you're going to tweet, and we do want you to tweet, it's CALIcon18. Tonight's reception is in this room. It's carnival food taken to another level, and some virtual reality games. So there's like a virtual reality roller coaster, and when you're in the rooms and we're doing the presentations, the keynote here is being streamed live. Hi, Jane. It's my wife. She's covering her face right now and saying, "Oh my God." We are recording, so the mics are live. So, be careful what you say, or don't be careful, because we'll just create a new membership category called People We Are Bribing. All right. There's one schedule change. The session, all the cool things Kelly is and could be doing is Friday at 4 p.m. That's tomorrow. It was Friday at 10:30 a.m. That's my session, so I'm really glad from this bully pulpit to say, oh, you should go to this. For 28 years, we didn't have a code of conduct. We now have a code of conduct, and for a moment, I want to get really serious. As an old guy, it bugs me that we have to have one, but it's an important reminder that we want people to have a wonderful time, and we don't want people to have a bad time. And so we have a code of conduct that basically puts people on notice for good behavior and gives them a method by which they can report problems. come to me, come to any of the staff, and you know, we'll talk about any problems that you might be having. You should be doing that anyhow. If you have any questions or things, we're happy to help you out. Now, this is a long-running conference, so we have a lot of traditions. I had to look up how to do this on WikiHow, but one of them is, you know, when you're in a swampy city like that, you know, you can share germs and stuff like that. So we don't, what's the word? We don't shake each other's hands. Instead, we fist bump around here. So you might see a lot of people fist bumping, and then you do the little Cali sparkle at the end. You know, and so 3 people have volunteered to help you with their fist bumping. John Haywood and Ken Hirsch have told me that anybody who sees them at any time, you know, can give them a mandatory fist bump. You guys want to raise your hand so everybody can see you? Here we go. Anybody sitting next to them, would you give them a fist bump right now? There we go, there we go, very good. Don't forget the sparkles. All right. One of the other traditions, of course, is me in a ridiculous costume. I've been an old man. I've been in a Lego outfit. I've been a Stig, the race car driver, Indiana Jones last year, and it all started when I dressed up as Elvis at UNLV when they built a new building in Vegas. Other things, the breaks. Actually, the best part about this conference is the breaks. You know, the sessions are good, don't get me wrong, but the breaks are the time when you get to talk to other people about the things that you're learning and things that you're doing. It was always intended to be not for techie people, not just for librarians, not just for faculty, but to get a slice of all 3 of them, or I should say, as a top predator, a bite of all 3 of them in one place and get them talking to each other. Faculty, law lives, technoids, whatever that might be. As for student printing, it's not allowed. No talking about student printing. You may notice that every single break there's going to be snacks. We call that the Perpetual Snack Initiative. We know that it's important to keep your blood sugar up while you're you know, going to so many different sessions. And apparently there's a beer hike, but I haven't heard about it yet, but I do have to say it's unsanctioned. John Haywood, do you have any information about the beer hike? Working on it, all right. See John Haywood or Dan standing there in the back. Fist bump. All right. All right, there are tours. I imagine that information is on the Flavor Flav, on the what do you call it, on the agenda. And now for our keynote, sponsored by Free. Thanks, Tim Stanley, really appreciate it. So Catherine, alternator, I always have trouble remembering your name, and so I tried to use like that memory word that was close to it. So I always thought of you as Catherine Carburetor, you know, but that got me screwed up, so I then thought of you as Catherine Alternator, which is close, right, but still the wrong spelling. Her name is actually Alternator. She's a long friend of mine, a fellow traveler in the access to justice space, you know, and the executive director of the Selfrepresented Litigation Network. She's someone who I've seen talk and talked to, and always felt like I'm really glad you're involved in this area, because you're so smart and so down to earth on your ideas, and that's why we invited her to speak. The SRLN was started by Richard Zorza. You can never mention SRLN without mentioning Richard and the amazing amount of work that he's done for many years. You know, what does self-represented litigants have to do with law schools? I mean, our point is that we train lawyers to represent people. We don't want them to be representing themselves, but it's a fact of life that an increasing number of people are either forced to represent themselves or are doing so by choice, believing that they have enough information from websites or from other places. I could have put up a picture of any of a number of reports or articles about the justice gap, but I just picked the most recent one from LSC. But I really think like it's a future, and it may not be a future that we want, where an increasing number of people will be saying, what are lawyers for anyhow? And that's a challenge that we have to meet. We have to evolve to meet that challenge. And so that's why I wanted Catherine to come talk, and why don't you start heading up here, and we'll swap out to have you speak. There we go. I'm a Tyrannosaurus Rex. I don't need any help. Whoops! Thank you. Whoop, 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 whoop.
There you go.
All right, I'll be right back. I'm going to go towel down.
Thank you, John. Join me in thanking John. Good morning. It's a great pleasure to be here today with all of you. Happy 28th anniversary to the CALI conference. For more than 3 decades now, John Mayer and his team at CALI, alongside all of you, have been leading innovation in the field of legal education and technology, and demonstrate daily in your work how the intersection of the two have a powerful synergy in promoting access to justice, as well as the modernization of the practice of law. And ultimately, how law students understand the role of technology and access to justice will make all of the difference in the years to come. When I told my 16-year-old daughter the title of this talk, How Do Lawyers Get Paid If Access to Justice is Free, she wrinkled up her nose, looked at me, glancing up from the iPhone, and said, "Donations?" And I thought, she is absolutely right. That is the traditional model we've been operating under for hundreds of years. Donations of lawyers' time, and crossing our fingers that the right objection would be made, the right appeal would be taken, and that justice would somehow be delivered. However, what I submit to you today is that because of technology, we're no longer trapped in that rigid paradigm. I believe that technology can enable us to deliver a significant amount of access to justice for free, and that lawyers can contribute to access to justice in new ways other than donating their time. In other words, they can get paid. Don't get me wrong, donating time is still essential, but I suggest that we look at pro bono activities as an investment. Pro bono provides an opportunity to invest in professional skill development and discover and open new markets with moderate income clients. Lawyers can get paid now in new ways, in new markets, at higher volumes, and with new skills and expertise. And when those are combined with technology, we can deliver more meaningful access to justice than we have ever had. So even just 5 years ago, when we were talking about technology and access to justice, we thought of technology as a tool that would give us scale, reach, and quality. But today we're experiencing radical changes in society in how we relate to one another because of technology, whether as family and friends, or how we obtain financial services, medical services, mental health services, education, and even navigate from one location to another. All aspects of our lives are changing because of technology. So now I think the question has become, what role ought technology play in our lives and in our legal systems, and how do we need to change our human behaviors to optimize technology? I know from your history that I'm talking to a room full of innovators. I think the most valuable thing I can do today is to unlock your imaginations in new ways so that you, professors, librarians, students, and technologists, can work together to develop innovative and creative solutions for the 21st century practice of law, and that the challenges presented during this period of realignment and modernization of the legal profession become inspiring opportunities for change. I'd like to begin with 3 seemingly unconnected stories about birthdays, the board game Monopoly, and the stock market. However, taken together, my hope is that they will help you think in new ways about innovation and adaptation. Can I have a show of hands in the room? How many people, when celebrating a family member's birthday, eat birthday cake after a meal in either the afternoon or the evening? So in my family, we eat birthday cake for breakfast. In fact, we do the whole shebang first thing in the morning. The kitchen table is decorated the night before, the presents are displayed, and the birthday person is escorted downstairs to the kitchen and ceremoniously seated before a blazing cake. We sing songs and give gifts. Everything happens before we eat breakfast. This is a tale of innovation and general overall increased happiness for all of the participants. It gets to the point straight away, and it allows our family to honor and celebrate the birthday person without distraction. While it does absolutely turn the rules on their heads, it has no downside, and it is not disruptive to the rest of the day. The birthday person is free to enjoy celebrations with other family, other friends, but we have turned the rules upside down in our house. So for most of us, Monopoly ends when we get tired of playing, right? It just goes on and on. However, if you read the rules, it technically ends when one player bankrupts all the other players. Have any of you ever been bankrupted in Monopoly? Ah, excellent. Okay, very few, but at least there have been some. I have been bankrupted twice by my 8-year-old daughter. Now, my oldest daughter likes to win, and when she was 8, now she's a teen. But when my daughter was 8 years old, she liked to win, and she likes to win fast. She was frustrated by the fizzling out that seemed to be the way with Monopoly. So she figured out how to win by creating derivative markets. She invited select individuals to buy insurance from her. They would pay an initial fee and then a very small premium as they passed by her properties. The non-insureds would pay full rent, but the insureds paid reduced rents. What a deal, right? It's worth noting that the insureds also had another opportunity. They were able to take a loan out from her that was due immediately upon the next time you got any money, or you could just hand over a low-value property to her and she would erase your debt. With these alternate sources of revenue, Gwyneth was able to stockpile cash quickly and far in excess of anyone else, which in turn allowed her to put up properties like crazy. Because her revenue was extracted from others, we didn't have any money to build on our property, so our rent payments were negligible. Ultimately, and in fairly short order, she sucked all the money out of the market and left us bankrupt. This too is a tale of innovation, but one that creates new complexities and also new opportunity. It is disruptive, and it creates new gains for some, in this case only one, and losses for all the others. The final story I want to share with you is the stock market. This is a picture of the floor of the New York Stock Exchange. The New York Stock Exchange is one of the most complex and impactful environments on our planet today. The impact of technology on financial markets across the globe is frankly more than I can or even wish to fathom. Our markets are largely being controlled by algorithms, and a tiny mistake can have enormous consequences that can literally wipe out individuals, businesses, and possibly countries. Therefore, quite a bit of attention is paid to the intersection between people and technology when it comes to financial markets to ensure that they are behaving in ways that are intentional and controlled by human decision-making and not accidental and controlled by unaccountable computers. I recently heard a speech by Stacey Cunningham, the newly appointed president of the New York Stock Exchange. in which she talked about the critical importance of properly aligning technology and people. She talked about how complex the markets have become over the last decade, and when that complexity is combined with technology, the impact of just one mistake is amplified exponentially and can quickly spiral out of control. Ms. Cunningham noted that the complex systems must always have mechanisms to mitigate damages, and that the kinds of redundancies, guardrails, and monitoring systems needed have had to evolve and adapt as technology increases capacity, scale, and complexity of markets. We're all well familiar with the need to create redundancies in the event our hard drive fails. This schematic represents a well-embraced necessity when it comes to data protection. We're not at all flustered by the notion that we must have a plan for when disaster strikes so that we can recover our data or, at the very least, mitigate our damages. The legal system is a complex system, and sometimes we forget to simply accept and instead become frustrated by the reality that we need to build new redundancies. This frustration can also lead to missed opportunity. I submit to you that the key to understanding how people and technology work together in the 21st century lies in understanding the historic way in which redundancies were built into our complex common law system. So, loosely summarized, the rules of procedure are our guardrails. The lawyers and judges are our redundancy. Combined, they filter, they identify the relevant, they object, they introduce, they argue, they rule. Appeals serve to monitor, correct, and mitigate. The questions before us now are what changes have occurred and how do we manage the complexity of our modern legal system in light of those changes? So the first major disruption is the rise of the self-represented litigant. The system was built for lawyers. We have not yet meaningfully developed redundancies for self-represented litigants. We still want the lawyer to be the person we insert into the system to be sure justice is delivered. But as you may know, nearly all people in civil legal proceedings are without a lawyer and represent themselves to secure their basic legal rights in matters such as housing, safety, food security, health, education, wages, family matters, and more. The study that John put up on the screen notes that 14% of legal problems encountered by the poor get legal attention. The rest go unhelped. The scale and drag of the entanglement in civil legal matters that people in America face cannot be overstated. Reviewing case data provided by the National Center for State Courts, SRLN estimates that 30 million people per year are appearing without legal representation in state and county courts, civil courts only. Millions more appear in the tens and thousands of unregulated municipal courts. Beyond state, county, and municipal courts, millions of Americans are also left on their own to navigate state and federal administrative proceedings, which disproportionately involve the most vulnerable among veterans, the elderly, the disabled, children, the homeless, and hungry, who are seeking to maintain or obtain benefits that have been designed specifically to help them and lift them up. While hard counting is difficult, it's not unreasonable to estimate that 40 to 50 million of the 240 million adults in America are entangled in some way in the civil justice system on their own. In other words, we're talking about 20% of the American population, of the adult population. The next disruption of relevance, I think, as we consider technology and lawyers and access to justice, is around the tools that we use. I think when trying to improve a system, one has to think very carefully about what has changed and what remains the same. Notably, the fundamental tools necessary to practice law have exactly the same purpose as they did in 1700. We need to write down our words, store and distribute our words, our knowledge, our learning, and communicate with our clients. A lawyer in 1700 needed a scribe, clerk, office, press, bookbinder, library, postal system, and a horse. In 1950, a lawyer needed a typewriter, a secretary, library, postal system, phone, and meeting space. Today's lawyer only needs a laptop and cell phone. Contemporary tools, though, serve the same immediate practical purpose, albeit with far more reach, fewer intermediaries, and significantly reduced space requirements for meeting and storage. In other words, the essence of being a lawyer has not really changed at all. We help solve people's problems by reaching into complex bodies of knowledge and skillfully communicating with our clients and others. But everything is faster. The world is flat. The speed and reach of how information and knowledge spreads is literally astronomical. I spent about 20 years in Alaska before I came to DC to head up the Self-Represented Litigation Network. I was a legal aid lawyer, and then in 2001, I went to the Alaska court system and started a self-help center. Now, for those of you who have ever heard an Alaskan speak, I'm about to say what we always say. If you take Alaska and you superimpose it on the lower 48, it reaches from the East Coast to the West Coast. If we had time zones in Alaska, we would have 4. It's big. It's really big. So in 2001, I was hired and they said, start a statewide program in the basement of the Anchorage courthouse. And you have 2 non-attorney staff. It's like, well, there's a challenge. However, I had been a follower of the development of hotlines in the aging grant world. And I thought, we're going to use a hotline and we're going to use the internet. Alaska was, even in 2001, incredibly well wired. Senator Ted Stevens had built a backbone of internet access in rural hub communities in the schools, and so people could get to the school and use the internet. In fact, the rural, the most vulnerable population in our state were more internet savvy in 2001 than people in urban areas. When I was hiring staff in the court system, one of my questions was, do you know how to use a mouse? And not everyone could answer that question. So we were able, in 2001, to build, between the phone and the internet, a virtual statewide self-help center that helped people in contested matters in courts throughout the country, or throughout the state. And that gave people access in a way that they had never had. I remember an early client or customer who called us and she said, you know, I've been trying to get divorced for 12 years. Could you help me? And we could. And it was really only the phone that made that possible. The fact that we were there and she called. Up until that point, she just had no one to call. There were paperwork, we could send it to her, but it was literally that connection that was so important. After I left the court system, I started an exclusively unbundled practice in Eagle River, Alaska. And when I had that practice, I Skyped with client soldiers who were in Afghanistan, and I talked to them between missions as they worked on their cases. I participated in court hearings hundreds, nearly 1,000 miles away from my office because Alaska permits remote access. Data and information travels in a blink of an eye, and big data analytics allows us to see new trends and new realities. Some we'll like, some we won't. Most will be a double-edged sword that we need to think about. I think once we catch our breath and fully internalize that there will be good, bad, and ugly in this new world, we're ready to experiment with what brings people and technology together in safe and productive ways. Now that we've looked at how humans and technology have changed, let's examine a little bit the underlying principles. I submit to you that they've stayed the same, and I think we sometimes lose track of that as we talk about the role of technology in the development of the legal profession as well as access to justice. People struggle to define what is access to justice. This is my definition, ginned up for you today. The timely use of personal legal help to achieve the best justice outcomes under the circumstances. The words that are in color, timely, personal, legal help, and justice, I think are the things that technology is impacting in huge ways, right? Timely means anytime, 24/7. If you're a lawyer today, you are available arguably 24/7, or your client can provide information 24/7 to you. The use of personal legal help, in other words, something that's personal to you, not just generic information. And what we're seeing in the field of access to justice now is trying to figure out what can we scale, what information can we generalize and centralize and put on websites and give people access to general information, and then how do we build in the systems to connect the individuals to a person that can offer more customized back and forth advice or information. Legal help. Legal help historically meant legal advice from a lawyer representing you. Today, we are beginning to take a much more general understanding of that to also include the work of non-attorney legal specialists. Legal help is information. Legal help is navigation. Legal help is helping people know what comes next. It isn't just advice customized for a person's situation. And then the best justice outcomes under the circumstances. So one of the examples I love to use is landlord-tenant law, which, of course, a lawyer makes a significant difference in those cases. However, the best and winning legal argument might not be the best outcome for the individual under the circumstances. So let's say you have a client, there's a technical error in the way that the notice to quit was given to them. The legal aid lawyer can say, slam dunk, we win, let's go to court, we win, we can buy you more time in your apartment. But the next step is to keep talking to your client. What's their situation? Maybe they're just never going to be able to afford this rent. Maybe the best option for them is to take the couple $100 in their pocket, buy a bus ticket, and go live with their brother and kind of reorganize things or maybe get a job there. Thinking about what the best legal outcome has got to be more broadly considered to the needs of the litigant themselves and also the practical outcomes and options that might happen. The second sort of set of principles that guide us, this equal justice concept, equal protection and due process. Nothing, despite all of the news in the newspaper every day, nothing has changed about these principles. We have a constitution, our play fair rules, and they're there. So technology has not changed those. How we affect those has changed. So I submit that these disruptions have not changed the principles, but rather the changes that have happened give us new opportunities to better implement these principles. So I have to say, I did not speak to the dean before preparing this speech, but I would say we are in I looked it up, was I supposed to say epoch or epic of learning? I'll follow the dean, epoch of learning. So how do people and technology evolve to better secure the promise of access to justice? First, I think it's just a completely open question. I think sometimes technology will better serve our needed redundancies, and sometimes it will not. Machine learning and AI will be able to identify outliers in the flash of an eye with tireless reliability. But what we do with that analysis is a completely open question. For instance, arguably, the affirmative defense that the statute of limitations has run could be pre-screened in an automated fashion with every filing. I would argue that for cases about to be barred or dismissed under this kind of system, a human should get a second pass to evaluate whether the data given was accurately and properly submitted. This combined approach would uphold our principles and actually improve justice in two ways. Time-barred cases would not unfairly sneak in because of human error. And timely disputes would not be shut out because a computer did not understand that a human error had been made. Another area where AI and machine learning could expand access to justice tremendously is that in the area of fines and fees, and the ability to pay analysis that a court is under an obligation to do, and they almost never do it. And for those of you that are not familiar with this, when somebody gets a fine or a fee from the court, the judge is supposed to inquire what your ability to pay is. And it's supposed to be an objective analysis. What we have is judges often deciding that you can pay because you have fancy shoes, or in the case, a case in Montana that was taken up on appeal by the Montana Legal Aid Society because she had a nice manicure, so she could pay for anything. If courts asked people to file their financial information at filing, to include that information, and that was in the system, the mathematical calculation of that person's ability to pay a debt on the outside could be made and a recommendation made to a judge. This would be an objective, reliable system. This is another example where we get a win from technology, but in other places, we might not. So, as I was preparing for this talk, and I was thinking about my daughter and her crumpled up nose and donations, and so I got kind of defensive. I thought, wait a minute, I need to make the case that access to justice is becoming free. And I thought, you know what, it really is. Access to information via high quality websites is free to the consumer. We didn't have that certainly 10 years ago in most jurisdictions. We still have some jurisdictions that don't provide that. We've learned from Rebecca Sandifer's work that people really don't know that they have legal problems, much less legal solutions. Providing access to information can expose the idea that legal advice might help and provide a rational basis to invest in an attorney. I saw that over and over again working in self-help. As I explained the situation to somebody and it gave them information, they could see suddenly like, oh, well, so I need legal advice about that. Yes. And that would be worth hiring a lawyer for. Yes. For a discrete piece. It was something they could afford and it made sense. So with legal information in hand, people are more likely to invest in a lawyer's advice about how to accomplish their goals. Everyone has a limited budget, but information can create a new kind of demand. Access to solutions for simple matters could range from out-of-court facilitated agreements to online DIY automated solutions. There is a huge movement in online dispute resolution in the courts. They have decided to adopt it and are going full force. A couple of weeks ago, I was talking to a few vendors in this space, and it's estimated that, and nobody can really count because it's happening so fast, but it could be 60 to 90 courts already have ODR in place and running. People want to be able to solve simple solutions without complex litigation. And I think this kind of access is critically important for us to preserve the legitimacy of the system. And it does not undermine the lawyer's role of advising what the best course of action is. I think lawyers are really mistaken when they view court complexity as their ticket to high earnings. The justice system needs to make sense, not look foolish. Some of the ways the court system currently looks foolish are when it requires multiple unnecessary appearances, or complex forms with completely unnecessary questions, or court procedures for ministerial tasks, or one of my favorites, service by publication in newspapers no one reads. Another place where I think the access piece is developing and is free is access to the law as written. Letting people see it for themselves. They can see the reality, they can see the complexity. When I write self-help web pages, I always include the hyperlinks to the relevant statutes for the case types that people are interested in. Now, are they going to understand necessarily all those details and what they mean? You know, I put the little disclaimer with it, but they can see it. If the people cannot read the law, we really are no better than the Roman Church prohibiting any language other than Latin. The law has got to belong to the people, and we need a transparent system. Another central obstacle to access to justice is just getting to court, or to a lawyer's office for that matter. The value of providing remote access to court appearances and court resources reduces costs to the court, the litigants, their employers, and local businesses. Technological solutions can allow us to get really serious about remote access. We could even flip the presumption for everything to be remote and give litigants the right to opt in for personal appearances when they feel it's necessary for them to get the best legal outcome. As I mentioned in Alaska, which is big, very big, we could do everything on the telephone. Would you conduct a felony trial on the telephone? No. That, as a lawyer, you would say, I need the client, the witnesses, the client, everybody in the courtroom. But many custody cases were handled with a judge sitting alone in a courtroom with a phone, and the litigants were calling in from different places, and they had a conversation, and they worked to solve the problems, because it was sort of a timing, scheduling thing. Being in that room, having to take time off from work, lose their job to get to that place, was not necessary. Similarly, lawyers who offer remote services to their clients will save themselves, their clients, and their clients time and money. They'll expand their markets by reaching clients throughout the state. You're no longer constrained to your county. In America, we have a huge problem with access to lawyers in rural locations. Urban lawyers can advise rural clients if they're willing to provide remote services. Lawyers can create more efficient workflows and easier payment options. I was able to serve meaningfully a significant number of people deployed in a war zone because I was willing to use technology. Access to due process is also increasing because of technology. It requires notice, opportunity to respond, and fairness. Equal protection demands each person is treated the same or equally. Technology allows us to notice anyone, anywhere around the globe almost instantaneously, far more reliably than that unread newspaper. One of my favorite cut-through-it-all judges was infamous for asking litigants to open their phone or their social media app and call or DM the service-dodging opposing party right then and there, and the judge would talk to them in open court. He just cut through it. The answer was right there. Technology allowed him to connect, allowed the people to connect. It also allows us to set a reliable and auditable floor in how we treat people and we treat information. In other words, we can actually prove whether everyone is being treated equally or unequally. So if all this access is free, where do the lawyers come in? I think understanding one's legal situation remains really complicated. And entanglement, as I described before, is at an all-time high. It has never been greater. By providing access to basic forms and information, we are creating a new demand for help. This new demand does not need to be bounded by geography or time in traditional sense. I think the new legal economy that you are educating your students to join is one that is a disaggregated, high-volume business that relies on free access to information to generate demand. The modern lawyer must actively problem solve, seek new insights and solutions that create markets and create new relationships. When lawyers and clients have freed up from that foundational and administrative work, they can better focus their relationship on considering whether there are legal solutions to improve their client's life. It's often said that lawyers would be able to practice at the top of their license. The modern Main Street lawyer probably gets paid more often for out-of-court counseling and problem solving than in-court work. The modern lawyer gets paid in smaller, more frequent increments, but is not sitting on a mountain of uncollectible receivables. The modern lawyer has substantially lower overhead. It's been externalized to the free court self-help. The modern lawyer develops value-added complexities that further their client's interests and stops relying on overly arcane court complexities to generate billable hours. The modern lawyer advocates for common sense, a user-friendly court system that allows the client's voice to be heard, and one in which the judges are making decisions on the merits, not just overseeing procedural skirmishes. So in this new epoch of learning, how do lawyers and courts adapt so access to justice is free and lawyers get paid? I submit courts must simplify. Lawyers must innovate, and both must adapt, accept, and recognize what's changing. Courts must simplify, but I can tell you they won't do it without the bar's blessing. So the call for simplification increasingly needs to come from lawyers. It needs to come from young lawyers who do not want to have to drive to court, stand in line, and waste 4 hours for a 15-minute hearing. Young lawyers need to be empowered to say, "Court, let us just call in for the hearing," or better yet, maybe we could just get rid of that hearing if we improved your forms. Remember the birthday cake? Why not have cake for breakfast? There is absolutely no reason to have multiple appearances for uncontested divorce. In fact, as in Alaska, for the last 10 years, we were able to dispose of nearly 80% of contested divorce hearings in one appearance by providing the right mix of technological and human supports in tandem with simplification. So much of the cumbersome procedure we face in courts today was created as guardrails for a system that did not have access to information, resources, and ease of communication that technology affords. Few things were reliably standardized. Is there anyone from Ohio here? So I hear that literally courtroom by courtroom, the forms can be different. A judge has the authority to make their own forms. That is the kind of antiquated lack of standardization that lawyers are relying on, that arcane procedure, to get paid, because there is no way that somebody can navigate that. However, if we standardize forms, now lawyers can actually do much more complex counseling and advising to help their clients. The systems we were built because we had to check and double check because we were building redundancies for human error. Multiple appearances create a form of redundancy. Are we sure? Are we sure? Wait, let's come back one more time. Are we sure? Technology, process analysis, differentiated resource deployment, including deploying lawyers and non-lawyer legal specialists differently, can be applied in all case types and result in sensible, simplified proceedings that better achieve justice. Lawyers need to be innovative, but maybe not exactly in the sense you're thinking. The word innovate comes from the Latin innovatus, past participle of innovare, which means to renew or restore. Consider this. Might lawyers renew or restore our place as counselors of law first? Legal education trains us to be exemplary problem solvers. However, under the current system, once minted, our problem-solving skills seem to immediately begin to shrink as we focus on how to navigate the rules, rather than make new rules that align with our timeless principles. Perhaps it is time to make new rules and to value our deep skills in things such as multivariable analysis, problem-solving, communication, persistence, networking, negotiation, comfort with conflict, as having a purpose beyond following the rules. I don't think the clients really want us to follow the rules. They want us to win, and they want us to win quickly. And they want to understand their options so that they can make the best choice under the circumstance for them. The new lawyer is supporting a client's autonomy. The new lawyer is letting the client dictate their future, not just an arcane system of rules that were made for lawyers. Clients might be more enthusiastic about paying bills if they could more easily understand how we make a concrete and measurable difference for them, and how we are not part of a broken system, but want to make it more efficient and sensible. When I was a legal aid lawyer, on more than one occasion, I would quote unquote win for my client, and my client thought that she had lost because I had won a legal skirmish. But from her perspective, the emotional drag and drain of the proceeding and the ultimate order, which was some kind of hamburger result, was a loss. As courts simplify and lawyers innovate, both will need to adapt to the new complexities that give rise to new strategies for resiliency and problem solving. We need to accept some challenges have, or should have, simply disappeared, especially when it comes to achieving scale, reach, and standardized quality, as well as access to information. The internet is ubiquitous. Millions of people can look at the same web page at the same instant and get the same information. Updates are instantaneous. Does anybody remember the interoffice memo and the interoffice envelope? There's probably a few people in here that don't, so I'll go over it. Back in the day, a memo would be written that needed to be distributed to everyone in the department or maybe the division. And they would put the names on the memo of all the people that needed to read it with a little checkbox. This got put in an envelope, and the first person on the top of the list's name would be written on the envelope, and it was a big envelope, and it had this lovely string you got to do this little figure eight thing with. And it got sent off to that first person. It went to there was somebody with a mail cart who took it around the building. They dropped it off in their inbox, and then they were to read it, check the box, put it back in the envelope, and send it off. Of course, if it got stuck in somebody's inbox, this was a whole nother business of tracking down where the memo had gotten waylaid. That's gone, right? Completely gone. There are some things that are just gonna go away, and we have to accept that and maybe embrace that and be excited that that's true. The dean I just want to say one thing about web pages and access to information through the internet. And the dean, importantly, noted that many vulnerable populations, and I would suggest it's much broader than vulnerable populations. I just think many people, and many people who we consider digital natives, kids with cell phones, what they're good at is pushing a button and talking, or not talking, they never talk, texting, or pushing an app to do one or two things. But people are not technologically savvy. I do not think that the majority of court users are technologically savvy. I have done lots of work in my career on plain language and writing forms and sort of the cognitive linguistic issues around form writing, which I'm sure many of you are well familiar with. What is fascinating to me is that one of the things we counted on with forms was that the information was still going to stay there. So you didn't have to remember what you filled out. In other words, if I filled out a form, I could keep going back and see, well, what did I answer to number 2? What did I answer to number 5? It was there, and then that helped inform your responses to other things. As we move to apps, the information is invisible. So for people that have low literacy, and if you look at the sort of functional literacy scales, only 20% of the adult American-born population has the skills to fill out a 1040EZ tax form or above. So 80% of our population is really impaired with court forms. One of the things is that executive functioning and keeping track of information and prioritizing apps are making it even more invisible. And we have really no research on that. But I think where we're headed, because we do need the value we get from technology, right? For the scale, the reach, the standardization. We don't want to abandon it. So what we're seeing develop is the rise of the non-lawyer helper, the navigator, the person that helps people figure out how to use the technology. So increasingly, it's always going to be technology plus person in order to really optimize those resources. But I also think we have to really recognize that there are, with these changes, opportunities for new economies, right? Who would have ever thought about selling insurance to force a timely win in Monopoly? I will note, though, that our family just quit playing Monopoly because the fun had been sucked out of it. None of us tried to set up a competing derivative market or introduce a new regulatory structure. We did not recognize or rise to the opportunity, we just quit. So in closing, I'd like to return to the interrelated notions of innovation and change. We need innovation for progress, but it isn't just for fun. Innovation alone connotes fun and excitement, new, uncharted paths, to boldly go where no man has gone before. Yippee, out with the old, in with the new. But in reality, that's not what's going on at all. We have a legal system with principles of fairness and equality that are unchanged. We need to hold the course amidst a storm of change. And so here's another imperfect analogy. The principles were adopted when we were in a rowboat, and now we're in a container ship. Our navigation systems are complicated, and few can actually understand them, but they are more reliable in the long run, and everything is moving faster, and we get to sleep in comfortable quarters out of the weather and sail around the world. But the path from point A to point B is probably still about the same. We just experience it differently. I think we must be determined to thoughtfully challenge the status quo as we innovate to make progress. The gift of technology promises new opportunities for how we work, and in doing so, can bring paid lawyer services to new markets. And if we remain vigilant in creating new redundancies, guardrails, and resiliencies that make sense and align with our principles, Technology can increase access to justice in ways that was unimaginable before. Thank you so much, and I wish you an excellent conference and exciting future. Thank you.
We have time for a few questions, comments. There's always a couple of beats before somebody has the courage. Chris, thank you.
Ask the librarian. Take a little bit. My library. We have is. I actually we're not.
Thank you. I'm catching the softball. This is one of my favorite topics. For the people out in the simulcast land, the question or the comment has to do with whether a librarian has indicated that she takes issue with information being free, and that she has to invest a good bit of time in helping people understand what can and can't be used, and it is not useful and transparent. Would that be a fair thing? Okay. So this is true in some jurisdictions, and this is not true in other jurisdictions, and this is the challenge we face. When we see courts taking ownership, and by courts, I don't mean the court law librarian who is doing just yeoman's work. I mean the Chief Justice, I mean the presiding judges, I mean the administrative office of the courts, taking ownership and responsibility for making their systems transparent. What happens is that we see the courts building very transparent step-by-step guidance on how to navigate through the procedures of the court. However, when the court doesn't take ownership of that, and it's left to third parties, librarians, legal aid organizations, you all have to operate within the boundaries of your mission and what your goals and objectives are. And you're not responsible for making the court system transparent. That is not your job. However, I would submit it, in fact, is the job of the Supreme Court and the administrative office of the courts, and that we need to start making that point. You need to raise that point in your jurisdiction and say, I can only help as much as the information I have. The courts control the information, they control the process, they have the power to make that transparent.
That's all true, but one of the problems is that
Yeah. So the comment again was that basically the laws are too complex to access and use. Yeah.
it's not even that they're too complex, it's that people access what's freely available, statutes, you have to click through all the license.
Yeah. And it sounds like the design of the system that you're in, it just it's ripe for redesign. It's ripe for statutory simplification. It's ripe for improvements of the way things are lined out. If proceedings are simplified, and again, we're talking about basic human need proceedings. We're not talking about, I'm not talking about complex civil litigation. There are jurisdictions that have very stripped down, easily to access, step by step, and you don't need to cite authorities. You can explain why you should have custody of your kids in plain language. And then there's other jurisdictions that you can't. So I think those concerns have to rise to the top in all of our jurisdictions.
Because it's a bit about not just the access to law and understanding the law and making systems and understanding the rules, but access to be able to play in that system. And if you're not there, they're just going to ignore you. Run all over you. That's the part that's always bothered me about tax suggestions. How do we give the people access to consistency that's needed so that when the law says X is going to happen?
Right. Yes. And that's where reform comes in. We don't want to teach people to be good in these really complicated, messed up systems, right? We want to change the system and make it less complicated. And I think, your community that includes a lot of, law students, the future of legal education. This is my point about young lawyers need to see this as part of their job, is to improve the systems, and the court is going to be reluctant to change so long as they think the bar wants it that way. So that's why I think the voice for reform, to the point of every jurisdiction is different. It is just overwhelming. We're a national network. When I first took the job, I naively thought, I just need a 50-state strategy. And then I realized I need a 3,144 county or county equivalent strategy. That's absurd, right? Like, we need to also work to change that while we increase transparency in these.
I'll try to project a little bit. I conquer I suspect many people in this room are. I agree with Agnes, and I suspect many of us like the idea of simplifying and standardizing, forming the system. But the humans don't disappear, right? So I'm just wondering if you have any insight into buy-in or financial or filing. I can think of many people whose reaction to that would be, I don't know if I actually want to trust the court system, so I don't know everyone have all of my finances for X number of years. We can also then go, I guess, sort of question of reform. I know a lot of young lawyers who would love to reform the system, practice and say, well, I mentioned it, older lawyers look at it like, my clients don't want to put the time for reform and they just don't want to. I can only bankroll so much when I have a small house worth of mortgage, something. How do you add any of it?
Yeah. Yeah, it's a ground game, right? Like, it's a ground game. The Self-Represented Litigation Network is a network of lawyers, judges, court administrators, librarians. Hopefully many of you are members, technologists, law students, funders, people who want to change the system. We have about 2,500 members nationally in that represent every state, and about 400 activists. That's still like a drop in the bucket. When I say activists, that means they get on conference calls monthly and talk to each other about how to reform things. It's always very opportunistic and it's very local, right? It's whether there's committee work and through pilots. When we network people across states, then maybe they're willing to try something out and they discover that the sky is not falling. The Conference of Chief Justices has made a very clear and unanimous commitment to access to justice and building 100% access to justice ecosystems through a series of 3 resolutions now. So there is authority at the top, but the ground game is where it's played, and it's slow, and it just takes people talking about it and finding the opportunities.
How many people have an innovation center at their school? Whatever it's called. Hands up higher, higher. Oh, wow. Much fewer than I would have expected. So I know of 60 schools that claim to have an innovation center of some kind. It might be technology, it might be access to justice, it might be design, it might be entrepreneurship, and things like that. And those to me are the manifests of how education is trying to, legal education is trying to get law students involved in how in change as it might occur in all kinds of places in the system. Do I have their hand up? Tim.
I sort of get what you're saying. I think technology will access and often areas that don't cost them. How we go. I don't really see how overall you have all these I think this, let's see how it's going to help lawyers, law, and even help. We can talk about folks that can help them over. Well, that can hurt that. Like it's just but I think for lawyers, I don't see how it's increased. I don't see how. I'm not saying it's not the right thing to do. For lawyers, it's better, and I do believe our associations went out of their way to try to judges are time. I think the law schools. So I'm not sure how this overall helps lawyer population.
Yeah, how many people are in a jurisdiction that has really well-accepted unbundling? And there's your answer. In jurisdictions that have adopted unbundling, where lawyers will do limited scope work, and let me back up for a minute. Unbundling, for some mysterious reason to me, is really faced challenges being adopted. The corporate lawyers of the world have done transactional work since the beginning. They constantly limit the scope of their relationships with their corporate clients to avoid conflicts and to just identify the part of all the corporate needs a corporation might have that they're going to work on. But when we brought it down to the people cases, so to speak, it seems to have caused some really great confusion when in fact it's a pretty simple principle. Instead of taking somebody's entire problem, you help them with what they want help with. Now, there are, depending on the jurisdictions, 70 to 100% of the people in the courts are without lawyers. People who get unbundled help are self-represented litigants for the most part. Unbundling does not always equate, and in fact, rarely equates to going into court for a variety of reasons. So I think where that new market is and we see that, where sort of there's scrappy young lawyers, this is how they're going to make a living. It's a totally different business model from a litigation practice. I mean, I ran an unbundling practice, and I had to run it entirely different than a litigation practice, but I worked less and made more than the traditional family law litigators in my community. But that's a business practice, and all the people, I'll just finish, all the people, we had very well adopted unbundling. It was hard to get a lawyer that had time to do it. The lawyers were overrun by this work because we made our practice work with the free information that was available. So I didn't have to bill for explaining or dealing with service. I say, go talk to Judy at the Self-Help Center for free. So what my clients that before would have never been able to pay a lawyer were able to pay me. But you're skinning rabbits, not elephants. It is a high volume business. So $500, $1,000, small increments, but you standardize your procedures and you're moving very quickly. To do that well, you need to have a predictable court system, predictable procedures. You need to have good self-help. So there's a lot of complexities, I think, that feed into it, but that's what I think the new market is.
It happens, right? You've got, now all of a sudden it sort of changes what people want. Once everyone starts doing it, I mean, overall, I mean, it just drives the price down and you start getting people that are not lawyers helping out. Again, I don't see how it helps the lawyers actually get work and get paid for it. Certainly a few people, but certainly if you only have a handful of folks, they'll get a lot of demand. But, as things get simpler and simpler, whether it's technology or whether it's third parties to do assistance, you can't really charge for just answering the phone or talking to them. That stuff's hard to charge for up front. I just see the whole thing going to, better for consumers, maybe more automated. Not necessarily better for the attorney.
One more question. Saw your hand up. No? Greg.
I have no idea. I think that, judges, again, right, they take case by case and circumstance by circumstance. The example that I gave you was just to show that when you think in an unbounded way, you can come up with new solutions that technology enables. I think most of the time judges would say they are out of their mind. This judge was a particularly creative individual. So, but my point being that we can use, the service rules are so antiquated. I mean, why are we publishing in newspapers? Nobody reads them. We can use technology. That was just the point to make. Yeah.
Great, thank you very much.
Thank you.
All right, stay put. The break, after the break right now is in this room. The food is already back there, but all the rest of the breaks will be in the space in the hallway between the vendors, right outside of here. We got a break for 30 minutes, so see you at the next session at 11 o'clock.